Good afternoon and welcome. Thank you for joining us today. I would like to welcome you to FortneyScott's COVID-19 weekly briefing. These briefings are held every Monday and cover the latest topics and developments impacting the workplace with regard to COVID-19. This briefing will be recorded. Everyone who registered today will be registered for all future briefings. The weekly briefings will continue as long as circumstances develop in regard to COVID-19. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's weekly briefing will provide an update on COVID-19 and a discussion about last week's Supreme Court decision extending Title VII protections to LGBTQ individuals in the workplace. The presenters include FortneyScott attorneys David Fortney, Leslie Silverman, and Bert Fishman. I will now turn the program over to David Fortney to start our weekly briefing.
Great, thank you, Valerie. Thanks so much, and good day, everyone. It's great to be here, along with, as you can see on the screen, Bert and Bert Fishman.
Good morning.
And Leslie Silverman.
Hi.
So we're
really
pleased to spend about the next 60 minutes with you. There have been a lot of developments this week, as there have been for so many weeks now. Let's first take care of a couple of the housekeeping matters. Just a quick word about who we are. I think, as most of you know, we are a Washington, D.C. Based firm. We do focus on the workplace and specifically on the federal agencies. In fact, the agencies that we're going to be focusing on and talking about today, as well as the courts. And so the areas that we're dealing with are exactly the ones that we counsel many of you who are clients on. Next slide, please. That being said, that although we do counsel you typically on legal matters, the point and the objective of today is to make sure you're aware of a number of developments, most of which have a legal underpinning. It's very important, though, that you do obtain legal advice tailored to your situation, and we would encourage you to speak either with your corporate counsel or to experienced outside counsel to understand how these developments actually impact your specific facts and situation. All right, well, let's spend the first bit of time talking about a number of recent developments, and there have been a lot. We're going to talk about the Supreme Court's decision affecting DACA, very significant. We're going to talk about some very significant EEOC developments. OSHA has continued to be active this week, including some litigation and other developments there. And then we want to spend the second half of our time with you today really talking about the Supreme Court's landmark LGBT decision in Bostock. We want to review to make sure you have a basic understanding, but primarily to spend some time talking about what the decision means for employers in terms of compliance and other challenges. As we go through today, as Valerie indicated at the beginning, if you have questions, please put them in that chat box. We will do our level best to make sure that we cover them. All right, well, let's jump right in on recent developments. The first one out of the box really involves DACA and so-called dreamers. And Bert, you want to start with that?
I'll be happy to. Next slide, please. You know, in any other week, this would have been the bulk of our discussion because this was one of the most important and long-awaited decisions of the Supreme Court. Just to remind you all, DACA is deferred action for childhood arrivals. It was designed to protect children under 16 who arrived in the United States before 2007. You had to have a very clean record, so all of the stuff you may have heard about thugs and felons, that doesn't apply to anybody who's protected by DACA. And the removal of DACA was one of President Trump's or candidate Trump's key points regarding the executive order by President Obama that established DACA to be illicit and an overreach, which is kind of ironic in light of all the executive orders we've had. But the important thing to note about this decision is that it simply said that the Trump administration may not immediately end the DACA program from protecting from deportation and other certain benefits that about 700,000 young people, now known as Dreamers, were awarded by President Obama. That is a revolutionarily important decision because it gives these folks the continued right to continue working in the United States. I just read an article that as many as a quarter of these folks are actually emergency responders, technicians, hospitalers, EMTs, ambulance drivers, firemen, policemen, and in the service. So these are very important contributors to the United States, all of whom have been educated in the United States, most of whom on the public dollar, obviously mostly in public school. This was a 5-4 ruling, a terrific setback for the expectations of the Trump administration, and most significantly, I think for a lot of us, it was the Chief Justice that wrote this decision, and he made the 5 of the 5-4, the traditional 4 liberals, the traditional 4 conservatives. And the fact that he did so, I think, is a signal that this Supreme Court is going to hold the administration to a kind of punctilious observation of all the procedural rules and all the procedural backgrounds. I'm hearing some background noise. If you could put your phones on mute, it would help everyone hear better. Thank you. The important other thing to recall is that this decision did not go to the
There we go. Okay, we're back.
moderator had to unmute. As I was saying, the important one of the key factors about this decision that you should recall is that this does not go to the merits of the case. As the last quote on this slide indicates, the court only decided whether the procedural formalities of the rescission of the executive order was done appropriately, and the court said it was not. So that means that the Dreamers are still in limbo, although to be quite candid, even though the administration has 2 or 3 times now said they're going to go back to work to try to do it right before November, before January, but in all candor, it took them almost 1.5 years to do it the first time. And getting your ducks in a row for something like this takes a significant effort. You should remember this has nothing to do with Congress, so all of the people in the executive branch can stay at work through the summer, through the recess, through the election, if they so choose, but anything that the court comes up with will be challenged in court, and we may be back before the Supreme Court before very long on the DACA issue.
One thing I want to make sure, Bert, that people realize that although most of the so-called Dreamers, the beneficiaries of DACA, were young, often, less than 5 years of age when they originally were moved into that status, as you indicated today, most of those are either in college or otherwise in the workforce. They have Social Security numbers, they're paying taxes. The whole point was that this group would be moved out of the shadows and put into the mainstream so that they would be aware so that there would be awareness and full participation as contributing members of society. So this is a very controversial proposal at this point, that is to remove them. It is possible that the administration could overcome what is essentially a procedural deficiency, is what the Chief Justice found. He did not opine on the merits. In fact, I think he suggested maybe on the merits there is authority, but they have to go through notice and comment and all of those steps, and as you indicate, likely litigation in order to get that done. Whether that can be done before the end of President Trump's term or first term remains to be seen.
Yeah, I think I noticed one other article that commented that over 60 rulings of this kind have come down from the courts, essentially saying that the Trump administration did not do it right.
Right. Right. That's exactly right.
I'm going to step off for a half a sec.
Yeah, Leslie, anything on this?
Yes, sweetie.
Leslie, your phone, we can't hear you.
I have no idea. I'm on the...
Leslie, I'm sorry, cannot hear you.
I don't know how to...
All right. Leslie, are you with us? No. We have a lot of audio gremlins,
now?
I see.
Am I unmuted?
Now you are, yes.
Okay.
Yes.
So I was going to say that my understanding is that to jump through the procedural hoops that the Supreme Court put up there and what they have to do compliant with the APA is going to take some work. So it would take, I just don't think it's conceivable that this administration can get this rule out. So I guess that's fantastic news for dreamers. How do you think employers, how do you think this affects employers, this decision, David?
Well, I mean, it's interesting. The dreamers have uncertainty, but what about the employers who have these employees who potentially are looking on fairly short notice of being deported back to a country where most of them never lived since they were, in their memory, since they were very young children. So the uncertainty cuts, I think, both on the employer community, certainly on the individuals, a lot of anxiety. Like I said, the decision's significant. It's procedural only, but it is nonetheless surprising. I think that many people had assumed that the Trump administration, and this was certainly one of President Trump's primary goals, was to accomplish this, and it's unlikely that that will get done now. This
yes.
All right.
Doesn't seem likely indeed. Sorry about the interruption.
Let's talk about that's all right. Let's talk about some other developments, those involving the EEOC. We go to the next slide, please. There we go.
Okay.
All right. So Leslie, why don't you kick off? As everyone recalls, Leslie formerly was the vice chair of the EEOC, so we have a subject matter expert with us on this today.
Yes. So, I would say that when it comes to identifying issues and assisting employers with compliance during the uncertainty of COVID-19, that the EOC has generally been on it. I'm not saying other agencies that I didn't work for weren't on it, David, of course. I'm just saying that I think that they are doing a pretty good job. They held a webinar early on in the pandemic that's still available on their website. And it was the EEOC's Office of Legal Counsel and some of the most knowledgeable people on the agency about, whenever EEOC issues guidance, they help work on the guidance and regulations and Q&As and whatnot. And they have since that time just continually kept up and issued several guidance in a number of forms. They have this Pandemic Preparedness in the Workplace with the Americans with Disabilities Act. And they have this document, which we have referenced in the slide, and this is the document that they keep up to date. It's called What You Should Know About COVID-19 and the ADA, the Rehabilitation Act, and Other EEO Laws. Mine's all marked up. And they have updated these Q&As repeatedly throughout the pandemic, and most recently, I think on June 17th. And whenever they update it, They let employers know, they let employees know, they issue some kind of notice, and they show in the guidance what they've updated and the date they updated. But I think generally when you look at these things, the rule of thumb is that in interpreting compliance to the ADA, the Rehab Act, the Age Discrimination Employment Act, the Pregnancy Discrimination Act, it's exactly as it would be in the absence of a pandemic, except where the EEOC is for the most part following the Centers for Disease Control, which is issuing its own guidance and interim guidance. And so when that conflicts with the EEOC laws, that's when they moderate their position in a different way. So consequently, early on in the pandemic, the EEOC that an employer that takes an employee's temperature or an employer who provides a COVID-19 test, well, that test would normally be a medical test that wouldn't be permitted under the ADA or the Rehab Act. But in question A7, in the prior questions, they've said those are fine. However, this week, EEOC issued a new question, A7, and that is based on CDC interim guidelines. And what it says is that the employer can neither administer nor rely upon an antibody test, and that's based on the CDC guidelines. Because they're not reliable. And so they are not consistent with business necessity for medical inquiry. So other things that
Leslie,
the EEOC,
Leslie, was the EEO moved by the reliability or the fact that this was a medical exam, which should, in the past, you could never administer?
I'd say it's the reliability as interpreted by the CDC. And by reliability, I think there's 2 points, Bert. Reliability because we now know that all of those tests are not the same. Some are more reliable than others, but also there's a lack of understanding. Well, if you do have antibodies, does that mean you definitely can't get it again? So I think there's 2 components to the EEOC's reasoning, but to say, well, it's just a medical test, well, so is a COVID-19 test. So that's why I'm saying the rule of thumb matters in these cases.
So it strikes me and that this effectively should, anyone out there who was thinking about using an antibody test as kind of a gating criteria on whether you would or would not allow someone to come to work, do not use it. The CDC says not to. The EEOC has now said you will violate the ADA if you do so. And there's just, it's not, from a scientific standpoint, it's not reliable. So not all these we can give you an absolute black and white answer on, but this one,
yes,
not using for that.
But
for
they
purposes
do.
of whether you can come to work or not. Right.
Yes, but they do leave wiggle room. They said it's subject to change because, of course, as the science develops and the CDC recommendations change, EEOC will look at that. So I think that, there are rules of thumb that you can think about. And whenever CDAC changes their position, EEOC is going to relook at, their prior ruling. But other decisions EEOC has issued are right in line with where they've come out before on issues. For example, under the ADA, an employer can and should try to accommodate an employee's request for a disability accommodation, such as telework, but an employer cannot use the disability, someone might be immune compromised, to require that employee to work from home. If it comes from the employer and it's required, it is going to violate the ADA unless the employer can make a direct threat, which is the exception for that under the ADA. If they could say somehow it was a direct threat, but EEOC is saying these conditions are not a direct threat. And they've taken this further under the ADEA. This is their newest guidance. They've said that an employer cannot say to employees over 65, even though the CDC guidelines do say that they are among those who are more likely to be immune compromised, that they cannot work. They can't use it as a basis for making employees over 65 stay home. Now, employees over 65 could say, I'm immune compromised. Would it be possible for me to have a schedule change or to work from home? And EEOC says that's fine. And it's even fine if the employer does not want to give that same schedule change or accommodation or working from home to employees under 65, even if they're 40 and over and actually covered by the ADEA. David, we're going to ask questions?
So this is the challenge of what I call the benevolent employer. The employer says, look, I'm really worried about you. You're in a vulnerable, you're susceptible. The CDC has said that you're particularly vulnerable. So guess what? You don't have to come back on that basis. And EEOC, I mean, there are workarounds, right? There are workarounds.
Yeah.
Which is.
There are workarounds,
yeah.
But you can't make somebody do it. So whenever an employer is trying to be benevolent, unless there is an existing condition right now, such as having COVID, you can't make a decision in what you think is employees' best interest based on that status. Go ahead, Bert.
I think the key word, and it's in the two bottom bullets, is involuntarily. You cannot force someone in a vulnerable category, which is how the CDC uses it, and they mean old people. You cannot force someone in a vulnerable category not to come to work. However, you can make an accommodation or a consideration or an adjustment or whatever fancy word you want to use if that person asks to be excluded from working from the office.
And Bert, what the nomenclature I think could make a difference. Accommodation is a term of art that we know under ADA and 503. We know what that means, or hopefully we know what that means at this point. This may or may not be a full-blown accommodation. It may be a consideration. That words may matter.
Yeah,
and we are counseling clients that and we think this is a good practice to, if employees want a consideration, that you do that, but that you not fully, quote, accommodate, you consider, because at some point you may want to end the consideration, depending on your business needs, et cetera. And it's not as easy to end an accommodation. So this isn't totally proven ground that we're talking about, but I think it's something that, at least in my thinking, is worth developing if you're going to implement these programs.
And as we also discussed in the last bullet, of course, this applies with pregnant employees as well. Pregnant employee, you cannot keep them out of the workplace involuntarily just because they're pregnant. Now, they may request an accommodation based on a condition related to pregnancy under the ADA, or they may say, well, I'd like to be treated as well as somebody else, situated to work, and might have an ability to request something under the Pregnancy Discrimination Act, but it's not for the employer to make that decision and involuntarily say, to people, you must stay home. Of course, some things that, employees might want accommodations for, and you could understand, is that you have they want to go to work, but they have an immune compromised spouse or child. But the ADA does not allow accommodations for other people. Right. Associational, you can't discriminate against someone because they have, somebody in their family that has a disability, but there's no requirement for an accommodation. So EEOC has, in the questions and answers, made that clear, that there is no right to accommodation. They've also made clear with caregiver and family responsibilities that, and we're going to get more into this when we talk about the Supreme Court case as it happens, but employers can provide flexibility on their own to workers with child care and family responsibilities, but they must do it without regard to sex, because if they only give it to, say, the female employees, then that would be discriminating against the male employees. So the other things that they've just briefly mentioned is they've also said, I just want to mention them, that if an employee requests an accommodation from screening based on the ADA or perhaps a religious accommodation, the employer has to look at those as well. And lastly, they have talked about harassment, and I mean, this is fairly common sense. You don't have to be working with somebody to harass them. It can still happen through technology. You know, I'm contacted frequently about situations that happen on Zoom calls, on conference calls, on, you know, Facebook and all of that. So just be mindful of that.
People are capable of being jerks virtually just as well as in person. That's what I've concluded.
Shocking. Sometimes they're bigger jerks technologically. Just saying.
Sometimes they, exactly.
Okay.
A whole range. All right. Well, Leslie, thank you for that excellent walkthrough. And the EEOC materials, as Leslie indicated, are online. You have the site, and they're very user-friendly and certainly should be reviewed by anyone who's responsible for implementing these programs in your organization. All right. Well, let's switch gears to one of the other agencies that was active last week. That's OSHA. And of course, OSHA's had guidance. And again, the whole point is under the general duty clause, there is not a specific COVID regulation. We're going to talk a little bit about that issue in a moment. But OSHA has been promulgating guidance, and they've done so for a number of different industries. And we've talked about those in the past, meatpacking, other industries. Next slide. This week, OSHA focused on what are called the non-essential businesses. And once again, OSHA has its own standalone guidance. It's been issued. The link is provided for your reference. This was last week. And it goes through essentially the same protocols that OSHA has previously described under the general duty, that you first rely on engineering controls, physical barriers, et cetera. We've talked a lot about that. Administrative controls, and there's examples there in the slide that discuss that. That's social distancing, work schedules, face coverings. Notice I say face coverings, not PPE. That is something else. But face, and then finally, also you should be doing a hazard assessment. And if the hazard assessment results that you need to use personal protective equipment, such as a respirator or certain coverings for your body and working, that's normally in at high level risk situations, typically healthcare, mortuary, other settings, most of which all of you in typical manufacturing or offices do not have. We're not talking about PPE environment, but that's how you determine whether you need PPE. Notice also that OSHA reflects what all of us know from our experience. Can we reopen? How quickly do we reopen? Are people still working from home? It depends. It depends on where we are, and it depends on, if you will, conditions on the ground. And by that, I mean, what are the state and local restrictions or requirements? And even those states that are wide open that have these hot spots that are coming up that have been in the news quite a bit, whether that causes you to recalibrate. And certainly a number of people are starting to do that. So businesses are opening, pulling back, trying to open, and I think that is going to become the pattern. That is the new normal.
Yeah.
Anyone have anything you want to add on that?
None on this one.
Hearing none. Okay. Let's go further. Next slide, because OSHA, not everyone's happy with this approach that OSHA's taken, and it's had its critics. We've talked before about the oversight hearing that was convened by the House of Representatives. Focus this past week has been the AFL-CIO. They did file litigation. They lost before the judge, and the litigation was to say, they went in and said, Judge, give me a break. You got to be kidding me. We have a pandemic, for God's sakes. Make that agency issue a standard. They're relying on some general duty point, and that's completely insufficient. That applies to everything, and therefore it isn't specific enough. That was the AFL's claim, effectively, to issue what's called an emergency temporary standard. The U.S. Court of Appeals for the District of Columbia, that's right below the Supreme Court. That's the most significant among its peers, the most significant, kind of sometimes referred to as the mini Supreme Court. They said, no, we disagree, AFL-CIO. OSHA has authority to decide. And it says that OSHA reasonably determined that an emergency temporary standard is not necessary at this time. It is very hard to compel an agency to issue a regulation. It's easier to get a regulation set aside. That's hard to do. Trust me, we've worked on those. It's very hard to compel an agency to issue a regulation. Bert.
Yeah, this has already become very controversial. I think one of the lead editorials in the New York Times today criticized this decision, pointed out that OSHA has in the past issued emergency standards completely within their authority to do so, could not imagine a more serious situation, pointing particularly to meat packing, chicken packing places where the hotspots are legion. So this decision is already being highly criticized.
Well, it is, and so we have the New York Times complaining. I'm not sure the administration cares a lot. Times editorial, but it's there for us today.
Well, we know the president reads them every day.
We have the AFL-CIO saying we're not taking this. Those are just 3 judges. They've asked the entire DC Circuit to exercise discretion and to review this decision further. Stay tuned. We'll see what happens. But in the meantime, we've heard from Secretary Scalia. And next slide, we'll talk about that for just a moment. Next slide, please. Secretary Scalia noting that basically defending, hold it right there.
That's right.
That they have not issued an emergency temporary standard, and it is a question of whether they have authority. They do have authority. It's that we don't need it. And he views it as unnecessary. We don't believe that for every new challenge, there must be a new federal rule, close quote. That is the Secretary of Labor's position. It's not unreasonable. In fact, the DC Circuit seems to think it's completely reasonable at this point. So you've got Secretary Scalia saying one thing, you've got the New York Times saying something else. Guess what? Scalia wins, New York Times loses in that type of smackdown, but it remains. The Labor Department has been under a lot of pressure to issue a standard. I think it's safe to say that unless they are compelled by a court, this Labor Department will not be issuing a standard beyond the general duty clause that's on the books now. So
yeah, that has been true from the earliest days of the pandemic. It's been true from the White House's position, and it's true from the CDC. I'm sorry, the pandemic task force. That it's not going to happen.
Right. So we did report, and we'll segue into this sort of our last point for the COVID update this week, that a couple of weeks ago, the Senate Judiciary hearing with Senator Lindsey Graham chairing the hearing, we have Senator Graham and Senator Klobuchar, who probably cannot even agree on what day of the week it is, actually both at that hearing saying, we think that OSHA perhaps should issue a standard for different reasons. Graham said, I'd like them to issue a standard because then we'll define a safe harbor. Anyone who complies with the standard, we'll put them into a new safe harbor. Klobuchar is saying, well, we need them to define a standard so we can hold people accountable and have a clear rule as to what they're expected to do or not do. The general duty is just that, too general. So that's the debate. That debate in the context of safe harbor is scheduled to continue this month with Senator McConnell. That the action is really in the Senate on that, and Senator McConnell will, I think, prediction will have a vote when he believes he has his vote whipped and in line and knows what the outcome is, and it will be probably more along the lines of what Senator Graham wants. Okay. Well, let's talk about probably the most significant issue that we have seen, and we were talking among us. I would hate to say collectively what our experience is as practicing as employment and EEO lawyers. It's a lot of decades collectively on this panel alone, but this decision, it's fair to say, is one of the most significant decisions in our careers, and is one of the most significant decisions under Title VII since its enactment in 1964. It's a big deal, and we want to spend a little bit of time unpacking the decision, and more importantly, talking a little bit about how employers should respond and what they're doing. So Leslie, I'm going to ask you if you would kick off our discussion initially on, let's start with the decision itself to make sure we're level set on that. Thank you.
Okay, let's talk first about the news about, who issued the decision and who joined in the decision. And it says at the bottom there, it was a 6-3 decision, and it was written by Judge Gorsuch, who was Trump's first appointee to the Supreme Court. And the Chief Justice joined in that decision, along with 4 of the more, liberal members of the court. And so that was surprising for some folks and certainly unexpected, but fabulous news for the LGBTQ community. This case actually was 3 cases. It involved Bostic versus Clayton County, Georgia. And in that case, the plaintiff, Gerald Bostic, had been a child welfare advocate for a number of years in Clayton County, and they had even won awards under his, because of his work, the work he performed. And at some point, Mr. Bostic joined a gay softball league, and it became known by people whom he worked with, and he was fired for conduct unbecoming a county employee for being part of the softball league. A second case, Altitude Express versus Zarda. In that case, Donald Zarda had been a skydiving instructor in New York, who'd also worked there a number of years, and he was trying to make a female skydiver who he was going to jump with feel more comfortable about being close to him, and made a comment about, "Don't worry, I'm gay," and was fired shortly thereafter. So those were both cases in which they were sexual orientation and was the issue. And the third case was RG and GR Harris Funeral Homes versus the EEOC. In that case, there was a funeral home director who had worked for the funeral home for a number of years, and shortly before going on vacation, wrote a letter. So started off as presenting as a man, but wrote a letter to her employer and said, "When I come back from vacation, I will be presenting as a woman." And she didn't. She was fired before she even left on vacation, and that was Amy Stevens. So in each of these cases, the employee brought suit alleging discrimination on the basis of sex. And Donald Zarda in the Second Circuit and Amy Stevens in the Sixth Circuit, they were both able to move forward with their suit. Those courts concluded that Title VII's prohibition of sex discrimination encompasses discrimination on the basis of sexual orientation or identity. But the 11th Circuit, Gerald Bostock, he was not as fortunate, hence why the Supreme Court took up this issue. And in this decision, the Supreme Court said that, in fact, the bottom line is gay, homosexual, lesbian, and transgender individuals are, in fact, protected under Title VII, and they are protected because of sex, as indicated in our slide. That quote there, because discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat individual employees differently because of their sex. An employer who penalizes an employee for being homosexual or transgender violates Title VII. Now, in reaching this decision, the court basically clarified the standard of proof. What an employee would need to prove intentional discrimination under Title VII. And what they said is, if the outcome would not have happened but for the discriminatory reason, in this case, sex, it violated Title VII. But the decision makes clear that this but-for causation means that even if there's multiple reasons for the employer taking the adverse action, if sex is a reason for taking the action, then that meets the but-for standard. It violates Title VII. So under Title VII, an employer cannot escape liability simply by saying that another factor contributed to the decision. So long as the employee's sex is a but-for reason, the employer is liable. I would also note that in the opinion, Justice Gorsuch focused on what it means to discriminate and talked about treating others, individuals that are similarly situated differently, that the focus should be on individuals, not groups. Yes. So in making this decision, the court pretty much sidestepped some thorny issues and in one case perhaps just teed it up, I think is the better way to look at it. It specifically said in the majority opinion, and Bert's going to talk about the dissents in a minute, that it was not addressing how bathrooms and locker rooms and related issues would come out. But with religion, it wasn't quite as quiet. It left open it left a rather large opening for employers who can claim that their conduct in taking an adverse action against the LGBTQ individual was religiously motivated. In the majority opinion, Justice Gorsuch actually referred to the Religious Freedom Restoration Act, RFRA, as a super statute. Now, he didn't exactly say how, when, or how often employers' religious liberty could displace or supersede Title VII protections, but there's a suggestion there. It's almost an invitation to come back to the court to work that out. So
I think also, Leslie, the religious the scope of the religious freedom claim also goes to individuals objecting to this decision, claiming their rights have been trammeled because they believe differently from Justice Gorsuch, for example.
The door swings both ways on that. Right. Well, Bert, let's spend 3 or 4 minutes on the dissents, please, and give us a sense of that, please.
Okay.
Next slide.
Exactly. Well, we had Justice, this dissent with its 3 appendices is regarded as the longest dissent in the history of the Supreme Court. It was an impassioned argument for the status quo. The lead quote from this is, "Sex still means what it's always meant," as if our language was somehow in granite, and of course we know that's not the case. But the main argument for Justice Alito is that this completely makes hash of what the English language means as far as he's concerned. He also notes, and this was one of the lead arguments and why this is a surprising outcome, that Congress has had many opportunities to amend Title VII to include LGBTQ, and on every occasion it has not done so. The EEOC has not done so except until the last few years. There's a long history of this issue coming before regulatory and judicial and legislative bodies, and they have never before reached this decision. He was impassionately outraged. And what's interesting about a dissent is sometimes they make the decision worse because they tell you in extraordinary detail every bad thing that could happen as a result of this decision. And that's exactly what Justice Alito did. And that's one of the reasons why Justice Gorsuch's decision went through and refuted every one of Justice Alito's points. It would have been great to have been a fly on the wall in those Supreme Court conferences because the windows must have been rattling. The most important
the majority at least addressed. I'm not sure they refuted them all, but it addressed them.
Yeah,
right.
They addressed them all.
There's a lot of back and forth.
A lot of back and forth. But this Justice Alito's dissent is the position of the conservative wing of the Republican Party. It is the position of the religious right. It states that they are being ignored and that their rights will be upset. And he predicts that there will be a generation of litigation. He also notes that there are over 100 federal laws that use "because of sex," those exact words, as the basis for their non-discrimination clause, and argues that each and every one must now include LGBT, and that with respect to each and every one, there's going to be litigation. If we could go to the next slide, because I want to move on to the implications. Justice Kavanaugh took a similar but different route. His main argument was that the step that the Supreme Court took is not one that a court should be able to take. A court should not make federal policy. That is the exclusive role of the legislature. He points out that there is a bill pending today that would have granted LGBT rights in employment as an amendment to Title VII, and predicted that it would have passed in the near future. Of course, people have been saying that since 1964 without success, but that is one of his main arguments, really a structuralist argument, and many people agree with it, that, you know, you've heard of the activist court and stuff like that, that this is the most active of a conservative judge to take a single word, a single clause, a single phrase in a large statute and change national policy as a judicial fiat. And that is the core of his main objection. He also, with Justice Alito, says that this really makes no sense in terms of the ordinary use of language. And as a result, if words don't mean what we think they mean, there's kind of confusion about what our laws can mean or should mean.
Right.
The most interesting for me part of this decision, and it was a long and well thought out decision, the last 5% of the entire decision was a praise of the outcome, a praise of the LGBT community for its tenacity, and a praise that they finally have the rights that they should have enjoyed time out of mind, which gives me the impression that in that judicial conference that they were having, is that Justice Kavanaugh offered this opinion as his middle ground for a majority, with the praise of the outcome, praise of the LGBT community, but saying this is not the role of the court, it's the role of Congress. He got one vote. There were 6 the other way, and Thomas and Alito had their own position. And we will see, I think, over the succeeding years. I think, in a sense, everybody's right. The majority established a national policy, and I think the dissents are clear that this will be contested for years to come.
Agreed.
Let's move on so we can talk about the implications.
Let's frame this for 1 second, which is that if this decision wasn't made as it was, we'd go on with where we are, and that would, I mean, most courts have found that transgender was because of sex. That was, I think, the easier of the two. And because of the Oncology decision, which was one of the Supreme Court decisions discussed, the prior decision, you had a situation where somebody was protected if they, weren't acting like their gender. So you had a situation where you could be fired for being gay, but not for acting gay. I mean,
yeah, same with Hopkins. Yeah, right.
Yeah.
Let's take these points and try to get them organized to talk a little bit about what future challenges employers may face. Because at this point, we have a very interesting and surprising decision. Like we said, probably the most significant decision under the Title VII, or certainly one of them, in its history. One of the questions raised is whether, there was, following Brown versus Board of Education, which was the school desegregation ruling in 1954, I believe, the concern, and there was, in fact, massive resistance and ignoring it. Is that going to occur now? I personally don't think so, because I think that social media has changed the ground rules a lot, and I think that there is more awareness, and I don't think that you can kind of, if you will, get away with what you could get away with in the 50s, where they tried to ignore Brown and sort of continue moving on a course that was contrary to it. So this is something that is at least possible, that there are those that are very concerned that there are parts of our country where this could occur, where people just say, I don't care what that court says, even though they're a co-equal branch of government, we're not buying it. That could be. I think the more likely point, though, is the concept of religion. And if you think about this, we have a protected status, in this case now sex, as defined by the majority decision. And we also have another protected status or interest, which is religion. And religion, we know, has to be accommodated. The statute says so. What is the balance? It is the only protection, religion, that requires accommodation. None of the others do. You don't have to accommodate because of someone's sex or race or national origin, but but a religion has to be accommodated. What does that mean? How is that going to play out? And clearly, a number of the justices have this on the front of mind. I mean, you mentioned before, Bert, about the RIF, or the Religious Freedom Act, being a super statute. It's so characterized. What is that going to mean? And then there's a subset. The ministerial exception noted there does talk about the individuals who are recognized in ministerial roles, and that can be fairly broadly defined. And just to remind people, religion is very broadly defined, a sincerely held belief. It's not necessarily traditional religion in traditional organized churches, synagogues, mosques, or other institutions. It's very broad under Title VII. So how does this play? And our employer is going to see people citing religious reasons why I don't want to be an emergency response team member with someone who is gay. I don't want to, because it violates my religious beliefs. Is that a possibility?
Well, frankly, that's where I think at least some of Justice Alito's reference to resistance came from. Not so much that employers in toto are going to ignore the law, but that individual employees motivated with sincere beliefs about their own religious views are going to be the ones objecting and resisting, perhaps even filing claims.
Yeah, I think this area and how this plays out, I think is going to become a very challenging issue. And we're not talking about people that are just, quote, bigots. These are people that do have religious beliefs and that are in conflict with this. And there are millions of those individuals in the United States of America. And the law says that it isn't automatically one or the other, and how to fit those together. Well, let's talk a little bit in the remaining time about some of the takeaways and how we follow from here. Next slide, please. Obviously, on this, I mean, the black letter law is now sorted out. That part we know. We may not know how that's going to be applied, but we know the black letter law. One of the reasons we say it's a big deal, because in 23 states in the District of Columbia, to varying degrees, there already were state or local law protections for LGBTQ status and protections in place. What that means is, for 27 states, that protection did not exist. So now, per this decision of a week ago, that protection is in place, assuming you have 15 or more employees, and most companies do, most employers do now. So that's one point. It's nationwide, that's the law. For those of you that are on the call that are federal contractors, hopefully this is not a change for you, because Executive Order 11246 up to this point was the only federal standard that actually expressly included LGBT protection. And that's because, recall, President Obama amended 11246 to so add that protection. So if you're a federal contractor, hopefully you've been complying with 11246, so this shouldn't be new. If you're in one of those 23 states or our home jurisdiction, the District of Columbia, this isn't new. But for huge parts of America, this is new. Bert.
Yeah, I'd also like to add, under traditional Supreme Court jurisprudence, those 100 laws that base their non-discrimination phrases on because of sex should almost automatically now be construed under the terms that the Supreme Court used in Bostock. That should be the way it works. So those will be interesting challenges if and when they come.
Well, not only that, DHS had new regulations affecting the Affordable Care Act, and the proposed final rule was to eliminate ACA insurance coverage for transgender individuals, using the definition of sex as the gender that one had at birth. In other words, the plumbing test, if you will. That is now, at least for Title VII purposes, out. The court has expressly reached that. And it's the same language. And those regulations, one immediate impact is those regulations are currently being retooled. They would have come out already and resulted in a rollback of insurance coverage, which would have affected transgender folks during the COVID crisis. So that already has had that impact to begin with. So I think
indeed.
How do you see the religious accommodation flashpoint issues arising? How, Leslie, how do you see that?
I mean, they have been arising for years, you know, even in this middle place that we've been in with the laws. Employees objecting to sitting through training because it talks about these issues. That's one way it arises, or expressing an opinion that's hurtful to somebody. I mean, that could be considered harassment. I mean, those kind of issues could come up, but I think a lot will, you know, with under religion and religious claims. I think the EEOC precedent. I don't know. It could all change with the court, but I think that's still going to be worked out, and I think employers have to just tread carefully. Of course, they have to make very clear that the federal law does protect the LGBTQ community and from discrimination and from harassment, and I mean that's the most important thing. So, if they have not updated training. Talk about these issues both for employees and managers. If you have separate anti-harassment training, I think it's important to do that. So, and policies, I mean, the vast majority of large employers already protect this under policy. And as we all know, and we often advise our clients, your policies often go much further than the law would go in these areas. So in many instances, they are it's already covered, but it is important to go back and look at the training, look at the policies. I've seen, training that refers to case law. You just want to make sure it's in line with this decision. It makes very clear that these folks are protected like everyone else.
Good. I know you do lots of work on training for some of the leading employers, so this suggests that that's a takeaway on updating the training. Bert, what about this point on the equal opportunity harasser, on whether that's a defense? What does that mean?
One of the interesting things about the way Judge Gorsuch articulated his position and the position of the court was that it doesn't really matter if your claim is that you treat each group or any particular group, male or female or other groups, the same. The law goes to protect individual conduct and individuals. So in that case, the mere fact that you say, well, I treat everybody poorly, that's not going to be the slam dunk winner they may have been in some courts. The whole idea is, are you treating an individual disparately? Are you treating an individual poorly? And this is the next point, if there is an element of that person's sexual preference, sexual identity, or gender as part of your decision. And if you'll permit me, the next point, the reason we think this is a really important takeaway is that we fear that this opens the opportunity for more claims from both members of the LGBT community and members of the religious right against employment conduct, and that there really may be the floodgates opening on claims to the EEOC.
So
I'd like to hear your views.
A couple points quickly, because we're right on our timeline. One, an individual who treats people adversely, either because she's a lesbian or he's a gay man, that same individual no longer is an equal opportunity harasser. He has violated the law not once but twice. And
correct.
Makes that point. So that is one point, and I think that's something that's going to be important going forward. The other thing is a but-for standard, fairly easy to meet, as long as it's a factor. Remember, this is under Title VII. This isn't just for sex claims. It's for all Title VII claims.
All claims. Right.
Except that
I'm going to give you the last word.
it's, as long as it's a factor, what remains to be seen is if another factor is religion, that's where it gets a little bit murkier, and that is still to be determined.
Good. All righty. Well, very good. Well, we're right on the hour. Leslie and Bert, thank you both very much, and thank you.
Thanks everyone for joining.
Thank you.
I would like to thank you for joining us. As a reminder, you may view the previous weekly briefings on our website at www.FortneyScott.com. And all registrants from today have been registered for future weekly briefings. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@FortneyScott.com.
Thank you.
Bye-bye, folks. Stay safe.
Thank you.